Thank you all for joining our webinar today. My name is Jessie Peterson. I'm the Director of Education here at SunRay Construction Solutions. SunRay secures $10 billion annually for GCs, subs, and suppliers. We're a national construction document service. Today's webinar is conducted by the incredible William Porter, a California construction lien law guru. Today's webinar topic is getting paid faster with liens, bonds, and contracts. So without further ado, I'd like to introduce the fabulous William Porter.
Wow, Jessie, thank you. Such a nice introduction. I don't think I deserve all that. I'm just a hard-working person like the people that are online. But I have been doing this for 35 years or so, and I've written legislation on these topics, so I can help out with this. And let me add at the very beginning, if anybody doesn't understand something we're talking about today, feel free to give me a call. Anytime in the next week or two, I'll be around and say, hey, I was at the webinar, and I don't understand something, or I have a question, and we'll just kind of consider it an extension of the seminar or webinar. Thanks, Jessie. So here we go. If you have any questions, you would go to the webinar chat box on the right, and then I will try to answer the questions at the end. Because other people will see this, please don't include company names or anything of a personal nature that could reflect on anyone. Okay? Great. So here's a kind of a little bit of a legal disclaimer. You know, I'm going to be speaking in broad concepts here to offer you helpful advice. But let's say, you know, I talk about a typical contract clause or something like that. It's always different. Every contract is different. We're going to talk about contracts just a little bit today. But anyway, if you really need legal help on something, be sure to contact your legal representative. Also, when you have someone who represents you in matters, make sure that it's someone who deals with construction law. If you're talking about construction law, if you're talking about, I don't know, something else, divorce law or something, then contact a specialist in that area. Always try to go for the specialist. So the first thing we're going to discuss today is contracts, because that'll happen before remedies and things like that. So there's a couple different ways to go on the contract. I realize that it is often that you have to sign someone else's contract, and when that is the case, you really want to offer edits. But the better thing than doing that is, whenever you can, use your contract that you have developed in concert with your attorney, so that it has clauses in there that benefit you, and not always obviously so. Sometimes a small change in a word can make a huge difference. So when you can, use your contract. If you have to sign the other person's contract, the person who will be paying you typically, then you're going to want to offer edits. Okay? What you want to do, one of the most important things I will say, is you want to limit the delay in paying. I know that there are clauses out there now. We're in California, and people use clauses from all over the place, but we have a rule in California based on this case on your screen called Clark versus Safeco. In California, it's not legal to say, I don't have to pay you if I don't get paid. Now, there are other clauses out there that say something which is similar, and I'll explain the difference. Some of them say, if I have a dispute with the owner, let's say you're a subcontractor, I have a dispute with the owner, you're going to have to wait till I resolve my dispute with the owner before I have to pay you. You know, that is a pay when paid, because it's a delay. It's not necessarily a pay if paid. But I have to say that sometimes those pay when paid, you know, the delay in payment cases, sometimes they go on for years. And that makes it, to me and to some judges, it makes it the same as a pay if paid clause, which is not legal. I mean, you shouldn't have to wait years. So what you need to do is you need to put provisions in there to say, yeah, okay, I will wait to be paid, but no longer than, and then you can put in something. Let's say no longer than 6 months. Or one of the things I like to do, it's kind of technical, but I would say maybe no longer than the period of time necessary for me to proceed with taking action on mechanics lien, stop notices, and payment bond claims, because these are some of your other remedies. Now, that seems like sensible. Okay, oh, I understand. You don't have to wait until you shouldn't have to wait until after you start having to get going on the mechanics lien, because those are the things you have to do to preserve your rights, and there's timelines and all of this. But really, if you think about it, when do you have to do something to protect your right to a mechanics lien? Well, actually, it's like when the project is completed. If there's a notice of completion and you're a sub, you're only going to have 30 days to start your mechanics lien process. So, and if you're a prime contractor, you have a contract with the owner, you're going to have 60 days after notice of completion. And if there's no notice of completion, you're going to have 90 days to, let's say, record a lien. So if you put in a clause like that, you change the delay in payment from could be years to 30, 60, 90 days. But you don't do it obviously. And so you can say, hey, I had to record my lien. Now you guys are in breach of contract because you haven't paid me. And they'll go, what? And you'll say, that's what the contract says. Sorry about that. Okay, there's a case called Krosno, which is kind of, it's a legal evolution in this direction. And what they said in that case, it's a court of appeal case, unlike Clark versus Safeco, which is the state Supreme Court, which is a higher level of case because it's the Supreme Court of California. The Krosno case is a court of appeals case. But anyway, what it said is that if there is a public works project and you have a bond claim, then the longest delay that case allowed was 6 months plus 90 days after the completion. And if the payment bond company hasn't paid, well, then you have a claim against them for non-payment, kind of the same as a breach of contract. So the law is evolving in this direction, but you need to offer edits as best as you can to protect yourself. Okay, next slide, thanks. Okay, some other things you need to put into your contracts. Put in an attorney fee clause, okay? If you're a sub, that's a good thing to do. If you're a large prime contractor, they often don't put in attorney fee clauses because they don't want to have to pay all their subs attorney fees when their subs win. I find that usually, in many cases, unless there's a major construction defect, subs often win their cases to a large degree, okay? So you want an attorney fee clause. The reason is because you can say to the GC, here's your argument. Among other arguments, you say, okay, GC, I know that you owe me the money, and maybe you did the earlier revisions and you haven't paid me and you're in breach of contract. I've not seen anything complaining about our work. I don't see anything about defective construction. There's nothing. So here we are, you owe me money. So here's what's going to happen, GC. We're going to get this resolved, but in the end, you're going to pay me what you owe me, right? You're going to pay for your attorney, right? But you know what? You're also going to pay for my attorney, and you're going to pay interest, and the interest can be high. Okay, so these are your arguments, and that's why you should have an attorney fee clause. If you're the only one who gets one in there, then they will resolve with you quicker than they resolve with somebody else. Okay, of course, it could go the other way if you're in the wrong, so you want to be in the right. When you're in the right, it's a really good argument, and it'll get you your case settled. Now, then you see clauses that are arbitration, mediation, litigation. I would suggest that you not do mediation. You can always voluntarily do it, but take it out of the contract, go right to binding arbitration. Often it is the least expensive and the quickest method to get things resolved. Mediation is the kind of thing where you have a third party in there trying to get you to settle, but you know what happens is that you do a mediation brief, or your attorney does, and you're spending all this money and all this time and all this aggravation and sleepless nights with the whole issue, and then you go into the mediation, you have your brief which shows them your whole theory, and then maybe the other side gives you a brief with nothing much in it, and then you go for a few hours and the other side says, you know what, I'm done, let's go, we're not gonna settle today, I can tell, and then it becomes a huge waste of time. Whereas arbitration it's basically a binding arbitration, and it avoids all the court things. So it's a good way to go. On interest, the maximum amount probably that you can add in there, which helps you on your claim, it's additional money, is about 1.5% per month. Now, there are also prompt payment remedies that can add to that. So, for example, if an owner doesn't pay you and you're a GC, you can get 2% a month. If you're a subcontractor and the GC has been paid for your work you can get 2% a month plus your 1.5% on top of it, which is pretty good. 2% a month times 12 is 24. 1.5 times on top of that is another. I think it gets you up to 42% if you get the 1.5% plus the 2%. That's 3.5% per month. That's pretty good rate of return. Okay. And then you'll have another clause to look for is the indemnification clause. I think indemnity is okay because it just means if you have caused damage to some other people, then you have to pay for the damage you cause. You got to look at the language very carefully, but what you want to avoid is the use of the word defend, because that requires you to hire an attorney to defend the party above you, the GC or could be the owner, or maybe there's a sub and you're a second-tier sub. You want to avoid having to pay for their attorney, so you want to cull out the word defend. Also, you want to look for the word solely and get rid of it for the most part when you're signing someone else's contract, because what it means is that unless a person above you is solely at fault, then you have to pay their attorney fees. That's usually what it means. But here's the problem, that someone is very rarely solely at fault. Because you may think someone is solely at fault, but maybe they're only 99% at fault. And 1% it's somebody else's fault, not even necessarily yours. So look for that word solely when you're signing someone else's contract and get rid of it. And you can use, as noted at the bottom, comparative fault. You want to get that concept in there. You may need your attorney to help with this, but what the whole thing is okay, if I am 20% responsible, then I will pay 20% of the damages, but that's it. It's going to be comparative. If you're 80% at fault, you're going to pay 80% of the damages and not dump them on me, okay? Anyway, those are good things to add into your contract. It's always, I get large contracts, 30 or 40 page contracts from people, and you can do this too if you want, but it's an expense. And you can, for the larger ones, maybe you want to turn them over to your attorney to get some suggested revisions to the contracts, okay? All right, next slide. Okay, very important in your contracts, don't mess up following the claims procedure, okay? There's going to be things in there that say you must do this within 7 days, you must do this within 10 days, etc. And if you don't do it, you may damage your ability to collect funds that you're owed because you didn't notify them within a certain period of time. Now, it seems unfair, but in many ways that is fair, because let's say you're a sub and you're dealing with the GC. The GC is kind of in the same position as you. They have deadlines with their owner. They have to present claims to their owner. And if you don't do it within a certain period of time, neither can they. And when you come later, a couple months later and say, oh, hey, I think I should be entitled to additional compensation for something that wasn't my fault. The GC, it's legitimate for them to say to you, you know what, if you would have told me right off the bat, then I would have presented it to the owner, but you didn't, and now I don't have the money from the owner to pass on to you. This is why we have deadlines in the contract. So follow the deadlines and make sure that you do everything that it says within those periods of time. Let me tell you about when you're editing the contract. So here's the protocol. If let's say you could type up a number of changes, and that's very professional, all that, but sometimes you maybe just write in the margins and you change some words, you cross some things out. So here's the protocol. You initial all your changes and then don't sign the contract at the end. And then you send all the initial changes to the other party that you're contracting with, and then they have to initial them too. Because in order to have a change, you have to have both parties initial. And then send it and say, please initial where I have initialed, sign it, send it back to me. Then when you get it back, you have all the changes are initialed, if they agreed, and then you have their signature at the end. Then all you need to do is sign it at the end and send it back to the other party, and then you have a contract containing all the terms. But if the other side doesn't initial the change or agree to it in some way that's clear, then it's not going to be part of your contract. So you need both sides to agree on every change. Every time you change a contract or a subcontract, it's a counter offer. and the other party has to agree, okay? Also very important, and this relates to things like change orders, delays, issues that arise on the project. What you need to do is you need to communicate in writing. Emails are just fine. And when you state something, you want to state the things, you know, factually accurate, but favorably inclined towards your position, okay? And if you're a person who is familiar with writing, you should know what I mean. Don't be inaccurate, but have a shade towards your position. And then here's the things that you can do on writing, all back and forth. You have to rely on other people being lazy. And you can say this, and this is effective, and I've used this many times. You say, if you disagree with anything I have stated above, please respond to me in writing within the next 2 work days. If I don't receive a response, I will interpret your lack of response as agreement with what I have stated. Okay, and then you do that, you put the onus on them to come back to you to disagree, and then when you go to a judge later, if you have to, the judge will go, okay, I see this here, it said respond within 2 work days if you disagree, Mr. GC. Where is your response within 2 days? And then the GC will say, you know, I didn't agree at all, but I didn't respond. I didn't want to dignify their position. And the judge will say, hey, you know, you didn't respond. It looks to me like at the time you probably agreed with them, otherwise you would have said something. Therefore, Mr. Subcontractor who wrote this respond within 2 work days, you win on the issue. So that happens. That's real world stuff, but you got to get it in writing. Everything that you say on the phone, all that, it's always good to write back and say, hey, confirming our conversation on the phone today, where we agreed as follows, da-da-da. If you don't agree with how I've stated it, please respond in writing telling me where you disagree within the next 2 work days. That's a reasonable way to go about things, and it protects you great. You know, it does a good job protecting you. All right, it's a good habit to get into. It's like playing the attorney before the attorney's involved, which saves you lots of money. All right, next slide. Okay, then if you don't get paid, okay, you're going to be looking at mechanics liens, stop payment notices, and payment bond claims. The preliminary notice, as noted here from SunRay, and they can do all this stuff for you. That's a really pretty one there. I like that one. Looks very motivating to the other side. Anyway, if you are a subcontractor or a supplier and you want to later on do a mechanics lien, a stop payment notice, or a payment bond claim, which is the subject of a whole separate seminar, then you have to send out a preliminary notice within 20 days of beginning work on the project, which is, you know, you can start that 20 days when you have a contract, some kind of agreement that says that you will do the work. And then you can't send it out any later than 20 days after you've been working. If you do, there's repercussions, which could take away from your right to make a claim. But even if you're late, you should probably send it out unless you haven't done anything at all and the project is over and it's been over for more than 20 days. But anyway, you have to have it as part of your procedure for subs and suppliers to send out the preliminary notice. Also, under the second line here, if you are a GC, a general contractor on a private works project, and there's a construction loan in place, not meaning just like a mortgage, but an actual construction loan with a construction deed of trust recorded at the county recorder, then those GCs also need to do a preliminary notice. So it's one step up, but GCs don't have to do it if there's no construction loan in place. All right, and in public works projects, the GCs and the first tier subs, those who have a contract with the GC, don't need to do a preliminary notice, but everybody else does. So if you're a second tier sub and below, you have to do a preliminary notice for public works. And I should note, with public works, you can't have a mechanics lien because they don't want public property to be sold. But you can have a payment bond claim, and you can have a stop payment notice, but you don't get them unless you do your preliminary notice. So always do that. It's very important, okay? You do that at the very beginning of the project or as soon as you have a contract. Alrighty? Next. Okay, then you're going to be using your releases. This is the subject of another seminar, but very quickly, there's 4 of them. There's conditional and unconditional waivers and releases on progress payment and on final payment. I note here, use them properly, okay? If it is conditional, it means that I will sign this and send it to you, and then you will send me a check. And then when the check clears, then by law, it becomes unconditional. But there's also an unconditional release, and when you send those, what it means is that, okay, I got my progress payment or I got my final payment, and it has cleared the bank. Therefore, I'm going to give you an unconditional release on progress payment or final payment, depending on the check. But do not give an unconditional release in exchange for a check, because then what can happen is that someone like a bank or an owner will rely on that unconditional release as they're entitled to, and then the check never arrives to you, or the check arrives and it bounces. Just make sure the check has cleared before you give any unconditional release. Okay, the mechanics lien. This is used on private works. It is great leverage. Let's say you're a subcontractor. You don't even have a contract with the owner of the property because you're a sub and you have a contract with the GC, right? But with the mechanics lien, you can jump right over the GC and go against the owner's property by recording a mechanics lien. And what it says to the owner is, oh, hey, Mr. Owner, Mr. GC did not pay me, therefore I'm going to sell your property and get paid. And the owner, of course, I mean, they don't want this to happen, and they will get all over the GC to take care of the situation. But if the GC goes bankrupt or something like that happens, even if the GC is paid, they're going to have to pay you regardless. And there are deadlines which are very important on mechanics lien. It could be, let's say for subcontractors and suppliers, it's going to be 30 days after notice of completion to record your mechanics lien. If you are a prime contractor, or the GC who has a contract directly with the owner, you're going to have 60 days after a notice of completion to record your lien. And if there's no notice of completion, or maybe there's a notice of completion but it's not valid because it's not timely recorded, which is another rule. It's going to be within 15 days after actual completion of the project, but that's kind of getting into a wonky area where you won't have the info probably. Anyway, let's say there's no notice of completion or an invalid notice of completion, then everyone's going to have 90 days to record their mechanics lien. And then after a mechanics lien is recorded, from the date of recording, the people have 90 more days to file a lawsuit to foreclose on the mechanics lien, and the lawsuit will include other claims like breach of contract, all this type of thing. But you have to pay attention to these deadlines, just like with the preliminary notice, which is 20 days after you begin work, although you could do it earlier. You have to record your lien within 30, 60, or 90 days, depending on the facts. And then once you do, you have 90 more days to try to get it worked out, so you don't have to file a lawsuit. You want to get your check and cash, and then release your lien. If the check you get is good and clears the bank, then you'll release your lien. But otherwise, you have 90 days to file a lawsuit. Another thing that you can do is a stop payment notice. What this is, and there's forms, and of course, you could do this yourself, but SunRay, this is their business, and they do it perfectly. You might make a mistake. I don't like to do these things myself because, well, as an attorney, then I have to be a witness in my client's case, and I don't want that. So we turn things over to groups like SunRay who do this every day, and they do it right. So I would recommend you do that as well. But the stop payment notice is great leverage against the general contractor because it stops money from flowing from the owner to them based on whatever the amount of your stop payment notice is, plus 25% on top of that. On your stop payment notice, there's deadlines as well. All these things have deadlines. You're going to have to send it within 30 days of a notice of completion or 90 days from the project completion if there's no notice of completion, like the mechanics lien. And then you would have 90 more days or more. There, you probably would have more than 90 days for a lawsuit in most cases. With a lien, it is strict, 90 days from recording before you have to do a lawsuit if you don't get it resolved and get paid. With a stop payment notice, it could be a little bit longer because of the way it's calculated. But the easiest thing is just to say, okay, if I sent a mechanics lien or a stop payment notice, I'm going to file my lawsuit within 90 days if I don't get paid before then. And then just watch out for the lies of the checks in the mail, or relying on something like if you get a check and it's like you're at 85 days, you probably need to file your lawsuit anyway, just in case it bounces. That's what I would do as an attorney, because people play games. People play games. They stop payment on checks, all kinds of problems. Or they close an account, you have a check and there isn't even an account anymore. I mean, people do bad things when money is concerned. People get desperate. Okay, next slide. And then your payment bond claim, that's your third remedy. Okay, if there is a payment bond. And we talked about that Krosno case earlier, where there's a limited amount of time that the payment bond company has to pay, 6 months, I think, plus 90 days. Anyway, though, that will be always on public works projects. There's a payment bond that's available, and these are things for subcontractors and suppliers to make a claim on, but there are deadlines. Anyway, that's your third method, and that's good, and it puts pressure on the GC as well, because the GC is going to have to defend and indemnify the bond company, so it's going to come out of their pocket. Anyway, you have mechanics liens, stop payment notices, and payment bond claims. These are the things that you need to do to get things resolved in your favor. If you miss the deadlines, then you're going to be behind everyone else. Also, let's say let's say you put in a mechanics lien and the owner files bankruptcy. Okay, in California, one of the big PG&E has filed bankruptcy twice. But you know what? If you have a lien, a mechanics lien, you are a secured creditor. The law requires that you get paid in full before any of the general unsecured creditors gets paid. So in the PG&E bankruptcies, 2 of them I've been involved in over the decades, we got paid in full on both of those, even though PG&E went bankrupt. And other people go bankrupt too, and you will be a secured creditor. Now, arguments to resolve things quickly, everything I said today, but of course you can't use these arguments if you're not in the right. And when you are, you're gonna, as I mentioned, you're gonna want to argue attorney fees, and both sides, whoever's in the right has a really good argument on this. And then the interest, and then there's those prompt payment statutes, which could give you the interest rate in your contract, plus 2% a month. So you could put in your contract 1.5% a month plus the 2% on top of that. That is a pretty good rate of return on an annual basis, okay? Up to 42% if I calculate correctly. And I will say this in closing on this issue: it's best to settle early and avoid unnecessary expenses, including attorney fees. If you can avoid paying attorneys, it's generally worth it to compromise a bit to get things resolved, instead of paying attorneys and having all the delay and aggravation. Even though I'm an attorney and I have a personal interest, I also have an interest in giving good advice to people. And one of the best advice forms of advice I can give is avoid paying attorneys whenever you can, by learning all the things like we discussed today that can help you to get the other side to settle with you and get the dispute behind you and move on. These things don't happen all the time. They're just you have to view them as an occasional business expense, business experience that fortunately doesn't come up all that much, and it's just kind of a cost of doing business. And if you have good procedures, good contracts, good ability to negotiate and raise the points we discussed today, you'll do better for yourself. Okay? What do we have on the next slide? That's it. I was a little long. I'm sorry, folks. But
No, you were amazing. You gave us a lot of really great information. Thank you so much, Bill. We do have a couple of questions that have come through. The first question that came through, it says, for a commercial or residential project, can I file a lien for only the retainage amount owed? And does this also apply to bond claims on bonded projects?
yes, you could, if you're owed the retention. One of the rules is that you have to be done with your work on the project, okay? Because then you know exactly how much you're owed. Yeah, certainly it could be for the retention, but also it will be for any other sums that you are owed. Using the theory that maybe there's disputed change orders, but you have to, if you think you're in the right, then you have to put those in also. It has to be a good faith amount. It can be for disputed change orders that you think you should be paid on. It could be for missed progress payments and your retention, all of it. Okay, every dime that you're owed, you can put into your lien, stop notice, or payment bond claim. But then, you know, you have to prove that you're right, ultimately.
All right, wonderful. Thank you so much for that clarification. Another question that came through, it says, if I go back onto the job site to complete punch list inspections and warranty work, is that considered my new last day? Or is my last day just a substantial improvement?
Yeah, that is a great question. Okay, so there is a distinction on punch list work. All right, if it is going in to do repairs, like you did some work, and then something broke on it. Let's say I'll look in my office, door handles, okay, on my door. Maybe you put in the door handles, but they're not working. They can't lock them. Something is wrong, and you have to come and repair it. That does not extend the period of time to state when it's completed. However, if you didn't put on the doorknob and it's incomplete work, then that would extend the time. And note this also, that the deadline on completion, it doesn't relate necessarily to just your work. It is measured from completion by all trades on the entire project. So you may be a plumber out there, but the electrician isn't done. So it's all going. It's measured by the entire project. If you're the only contractor, though, then when you are all done, then that is the last day of work. And if you go back out within, let's say, 30 or 60 days, maybe, I wouldn't go beyond 60, because there's another doctrine. Well, let's say you go out and you do some work that you hadn't done accidentally. That could extend the date. But if you just go out and do warranty and repairs, then that won't extend the date. There's another doctrine I should mention, and this is kind of, you know, the whole long, one of the issues from the whole long seminar on mechanics liens and such. There's a doctrine that says if no work has been done on the project, and it's not complete, but no work has been done on the project by anybody for 60 days, then that can be deemed to be a completion. Okay, and then a lot of people use that. They run out of money, they padlock the facility, they wait 60 days, and then they wait 90 more days for liens, and people aren't sure what's going on. But what is going on is they're trying to get to the date when people can no longer record any mechanics liens. And so when that kind of thing happens, you need to look at it very carefully, because there's going to be 60 days passing and nobody does any work. That's a completion. And then everyone is going to have 90 more days after that to record their lien. So be suspicious when a project just stops for a chunk of time. Okay.
All right, wonderful. Okay, and then another question that came through, it says, if my lien deadline falls on a holiday or a Saturday or Sunday, does my deadline then roll over to the next business day?
You know, that also is an excellent question. There are some statutes out there and some case law that seem to state that if it's on a Saturday or a holiday, it's the next day. But I have to say, I also have had arguments from people on that. And you want to avoid arguments. I don't even get close to the deadline. As an attorney, things can happen. You could go to the county recorder, there's an accident on the road and on the last day, and they're closed when you get there. Dang. or on a lawsuit. Sometimes you have to file in the court, and you're right at the last day, and so you send someone down to the court with the lawsuit, and they won't accept it for filing because of some error on it. So I never even get close. Yeah, there's a doctrine that says it's the next day that the court is open. Like what was it? It was Veterans Day yesterday, and I think most courts were closed, and that would come as a big surprise. But then it would be the next day. You know, and I've had arguments on it from other people. I don't want to pay my client to argue with some other person, so I never even get close, and I don't think any of you should either. Okay, but yeah,
that's good advice.
Statutes and like that, but never get that close. It's too dangerous.
All right, perfect. And then I think this is the last question that's come in. It says, on a privately bonded project, can you file a lien and also send the bond claim?
Absolutely, and a stop payment notice. You could do all three. So then when you do your lawsuit, you're going to have a claim for breach of contract because somebody didn't pay you. That's a breach of contract. You might have claims for prompt payment remedies because you didn't get paid. You're going to have foreclosure of mechanics lien if you record a lien. You're going to have to enforce the stop payment notice, and you are going to have on the payment bond. You can have all three of them. Now, that doesn't mean you get to collect triple, but let's say you messed up something on the mechanics lien. Okay, I have the bond claim to back me up, and I still have breach of contract as well, and the stop payment notice. So you pursue all of them that are available to you. You don't have to pick one or the other. Do them all, and then you sue for them all, and then you work it out, you know, during the lawsuit. Usually what happens, I'll tell you honestly, mechanics liens, it is so rare to actually go and sell the property, you know, in a foreclosure on a mechanics lien. Almost always someone comes up with the money because they don't want their property sold, or the bond company will pay, or, you know, somebody's going to come up with the money. It is so incredibly rare to actually have to go and sell the property. But you want to put everything you can down to expose as many people on as many theories as you can to the requirement to pay you. So yeah, go for all three.
All right, wonderful. Okay, so that does seem to be all of the questions. If somebody does think of another question that wasn't addressed, please feel free to reach out. We'll be sure to answer any questions. I know Bill had stated early in the webinar that if you have a specific question that comes up, you can absolutely reach out to him as well. So please let us know. All right.
Jesse,
these are some of Of course, these are some of SunRay's resources to help you stay organized, know your deadlines, and secure your lien rights. So go ahead and scan that QR code to access these. It will help you kind of keep all your information straight and in one place from the onset of your project, and you'll know kind of who's on the chain above you, so you know who to be sending notices to and what's expected of you. All right, and then if you don't mind, give us a quick review on Google. We really do appreciate it. It helps us kind of get some of that feedback and figure out what topics you're wanting to hear about and always improve ourselves. And with that, that is all we have for you guys today. Thank you guys to everybody who attended. We hope to see you guys at our next webinar. Again, Bill, you really are incredible. Thank you so much for your time. I hope you all have a beautiful and wonderful sunny day. Thanks again, Bill.